My Lords, I suspect that every member of your Lordship's House will oppose any coercive or violent attempt to change a person's sexual orientation or gender identity. Such activities are illegal, cruel and damaging and are to be condemned. Any offence involving physical violence, sexual violence or coercive behaviour in an intimate or family setting is prosecutable under the criminal law. Nobody should be subjected to such behaviour. My Lords, it's not easy to identify the constituent elements of the offence to be created under this bill. Matters of sexual orientation and gender identity lie at the heart of the bill, yet they're not defined. Ultimately, people are free to live with the sexual orientation or, to a significant degree, the gender identity which they assert. In most cases, gender identity and sexual orientation are irrelevant to a person's capacity to live their lives to the full as they wish, subject to the law. Some aspects of life do make separate provision, as noble lords have referred to. For example, sports, such as women's rugby, only permit players in the female category if the sex originally recorded at birth is female. There are reasons why these decisions are made. They're well rehearsed. The Equality and Human Rights Commission, in response to the government consultation on conversion therapy, cautioned that the legislation must be carefully drafted, not to catch illegitimate and appropriate counselling, therapy or support, which enables a person to explore their sexual orientation or gender dysphoria and to avoid criminalising mainstream religious practices, such as preaching, teaching and praying about sexual ethics. They said that encouraging people to comply with religious doctrine that requires refraining from certain types of sexual activity should not fall within the definition of conversion therapy, and that the offence should not capture communication such as casual conversations, exchanges of views or private prayer, with the distinction clearly defined in legislation. My Lords, the bill doesn't differentiate between children, adults at risk and other adults. And in pondering at this, I looked at the latest draft guidance to schools about gender questioning children, which was issued in December, drawn up by the Department for Education and the Government Equality Hub. It provides a really clearly drafted set of principles and proposed practices in the context of the difficulties which have been identified in how to respond to gender questioning children in schools. The guidance defines gender identity as a contested belief. It is a sense that a person may have of their own gender, whether male, female or another category such as non-binary. This may or may not be the same as their biological sex. They say many people don't consider that they or others have gender identity at all. I think this very recent definition is useful in attempting to articulate one of the difficulties with this bill. What the bill seeks to criminalise, as noble lords have pointed out, is a practice aimed at a person or a group of people which demonstrates an assumption that sexual orientation or gender identity is inherently preferable and has the intended purpose of attempting to change or suppress a person's expression of sexual orientation or gender identity. There's no definition of therapy, although it must involve some form of therapy, I think, aimed at one person or a group of people. The words of the bill, as has been observed, do seem to derive from the Memorandum of Understanding on Conversion Therapy, agreed in 2022 by a number of healthcare and counselling bodies involved in medical treatment and counselling. It's not applicable in other circumstances. The bill appears to make the word practice equate to any activity which can be carried out by a clinician, a teacher, a person, a parent, who may consistently express certain views, for example, when presented with the child who seeks to transition, that it's not right to give children life-altering drugs when we don't know what the long-term effects of such prescription may be, and who fears that the child may in the future realise that actually they want to remain in their biological sex. Or a minister of religion who advocates chastity outside marriage between a man and a woman in accordance with their religious beliefs. On the wording of the bill, it would appear that people in all these categories and others may be at risk of committing a criminal offence simply by engaging in discussions about sexuality and gender, and encouraging a person to think through the factors which have led them to a particular conclusion, and may be perceived by a prosecutor to demonstrate an assumption, may be considered by others to have an intended purpose, not a result of causing damage or harm. There are no exceptions and no exclusions from the scope of this bill. no consideration of the person's mental capacity or ability to consent, of the fact that a person may be seriously conflicted in their mind across a range of issues relating to their identity and may need to explore those issues in a traditional psychotherapeutic or spiritual context with a psychiatrist or other persons. My Lords, in the context of the bill, we need to ensure too that our statutory rights to freedom of speech, expression, belief, etc. are not unnecessarily or disproportionately reduced. It's most important that people are protected from abuse or force, but that doesn't mean that we cannot say something which may trigger someone or may cause them distress. In law, part of our lived experience is the process of acquiring resilience so that we're not inhibited by things that are said to us, even when they offend, shock or disturb. It's a criminal offence, my Lords, to use threatening or abusive words likely to cause harassment, alarm and distress anywhere other than in a private dwelling. Coercive behaviour is a criminal offence in an intimate or family relationship. Therein lies statutory protection. My Lords, there will be those who have beliefs and values, whether or not they belong to particular churches, and who want to understand their gender identity in this context or to live in conformity with their values or church teaching. They may seek spiritual guidance, help. Legislation must make space for that. Interventions may occur at difficult times, different ways, over long periods. For this to happen, others have to be willing to engage in the conversation of counselling. If this bill were to pass, there is evidence that psychologists, teachers, etc. may become unwilling to take the risk because of the risk of prosecution. My Lords, the bill is stated to apply to Northern Ireland. This is a devolved matter. It is for Northern Ireland's Assembly, which is now sitting to consider whether and how it wishes to deal with this matter. My Lords, the end result of this bill may be to deter someone from having conversations which may be vital to their mental health and future well-being. The matter of the protection of sexual orientation and gender identity is immensely important. For each of us, our identity, our sense of self is fundamental to our very being. This bill is insufficiently precise. It will criminalise people, it will impose unlimited fines because they have sought in one way or another, without coercive or physically abusive therapies, to help someone else.